Recording in progress.
Okay, good afternoon students. Welcome to lecture number 3 of paper 2 CA Inter Corporate and Other Laws. Now till yesterday we finished up till small company, and I think we have done one question also on small company yesterday directly from the exam paper. So let's revise a bit. Yesterday I told you that in the Companies Act 1956 there was only public company and private company. In Companies Act 2013, private companies have been further bifurcated into two more parts, small company and one person company, for the purpose of granting exemptions. So now we have private company, small company, one person company. Yesterday we studied small company properly. We also understood what is private company. Now what is one person company? Let's understand. One person company. The section for one person company is section 2 clause 62. What is the section? Section 2 clause 62. Okay, now what is this? Let's understand. One person company, first I'll write the definition, very simple. One person company means a company with only one person as member. One person as member. Now see, generally in the classroom I tell them to revise also with me. One person company means a company with only one person as member. Now guys, let's understand. The moment you read this word, one person company, for many people sole proprietorship comes in mind. Yes, and it is quite logical. People will directly attract to sole proprietorship. But beta, one person company and sole proprietorship form are two different things. I'll tell you the difference. First we'll understand one person company properly, then we'll go for understanding the legal provisions. Okay, see. One person company. It is a company formed under Companies Act. It is a type of private company. It is not a sole proprietorship firm. Sole proprietorship firm and sole proprietor comes, sir, what is it? Sir, does everything about Company Act comes under section 2? No, only the definitions come. Okay. So one person company, sole proprietorship firm and the sole proprietor are same person in the eyes of law. But one person company and the sole member of one person company are not same person. They are two different persons in the eyes of law. It is a company under Companies Act. And in company, beta, we know corporate personality, separate legal identity. So it is a company under Companies Act, type of private company, and that's the reason all the features of company, limited liability, perpetual succession, can sue, be sued, every damn thing will be there. Except only one change. In normal private company, minimum number of members to maximum 200. And in one person company, minimum and maximum number of member is one only. Am I clear with this thing? Now, sir, why this concept started also? I'll tell you. See, tomorrow if you go for articleship, your sir or in your office, companies would be clients, and companies AWA and MOA, AOA and MOA will be there. Now you take the MOA of any company, in fact in AOA also, take the last page, there will be a table. That table is nothing but the association or subscription clause, which gives details of the first members of the company. That is the reason we call it as association or subscription clause. These are the people who have subscribed the first shares, basically promoters. Now in a private company, if your client is a private company, take out the MOA, 99%, what will be the status, you know? 99%. It will be, the company has issued 10,000 shares. Out of 10,000 shares, 9,999 shares are taken by the husband. Husband and wife will be the member. And only one share will be given to the wife, just to comply with the law, minimum 2 members in a private company, right? And the directors are husband and wife only. So, and we show everything fake. You know, in normal companies, I told you yesterday, minimum 4 board meetings should be there. So we show minutes, we prepare minutes and we show for 4 times in a year husband and wife met Okay, in the board meeting, they came in the board meeting to discuss business. Do you think it is possible? No, we show everything fake. They came in the AGM. And lawmakers also know that everything is shown fake just to comply law. So if one person is actually handling the company, who is that person? General scenario, the husband is handling the company and wife doesn't even know what business they are doing. Just to comply the law, she is shown as a member and director. So if one person is actually handling the company and is capable, why are we burdening him with another member and director? Correct? And for that, one person company concept started. Let only one person handle the company and run the company. And from this section came into picture. Section 2 clause 62, a company with only one person as member. Am I clear with this thing? Understood everyone? Now there are some questions which I will ask you and I know what answer you will give. And exactly I know, see, I don't know you people, online people also and these people also. But I exactly know how you have studied in your 11th standard, 12th standard PUC. See, let's take, you people give me the answers, okay, if I ask the question. Tell me minimum number of members in a private company. Minimum number of members, 2. Maximum number, 200. Correct. Minimum number of members in a public company, 7. Maximum, there is no limit obviously. Minimum number of members in one person company, maximum 1 obviously. Minimum number of directors in a private company, 2. Minimum director is 2. Maximum online people, you tell me what is the maximum number of directors? Maximum number of directors. See, answer is blank. See, that is what I say. In your 11th standard and 12th standard, I think 11th standard joint stock company was there. So everyone studied, it is written there, minimum number of directors. Maximum is not there. You didn't ask your faculties what is the maximum number of directors. Answer is 15. I think some people give the answer. Answer is 15. Minimum number of director in a public company, 3. Maximum, it is 15. Minimum number of director in one person company, 1. Maximum, wrong, it's not 1, it is 15. A company with only one person as member, not as director. Do you understand? Am I clear? So basically it can be I am the member, I am the director, well and good. I am the member, you are the director, well and good. I am the member, 15 other people are director, that is also okay. Am I clear with this? That is one person company. Clear everyone? Yes? Okay, good. Done. Good. And okay. Now there are some legal provisions for one person company which I'll start, but before that there is an important section which we have to do, and that section is important, star mark I'm putting. Section 3A. Now section 3 tells a company may be found for a lawful purpose. Yesterday we studied. Section 3A, A capital A, you know, whenever capital A comes, it means it is added section. When the law was made, act was made, at that time it was not a part. Later on it was added. So what does section 3A tells? I'll tell you, see. It tells me, sir, I'll take example of private company, it is also applicable for public company. Example, beta, there is a company named as Bunty and Bubbly Private Limited. What is the name? Bunty and Bubbly Private Limited. Bunty and Bubbly are the members and the director, husband and wife. Example, they both went on a long drive. Bubbly told, we'll go on a long drive. They went on a long drive. Suddenly, unfortunately, they met with an accident. Bubbly died on the spot. Will the company die? No. Why? Perpetual succession. In fact, both the die also, then to company will not die. Will there be any instability in the company? As such, no. The reason is that Bunty is still there. But here, what is the minimum number of members in a private company? 2. But now there is 1. Can the company run with 1 member? Answer is for a period of 6 months, yes. Here Bunty has a duty to appoint a new bubbly. New bubbly means new member within 6 months. In case he appoints, well and good. Okay, company will run. But if he doesn't appoint a new bubbly within 6 months, then any contract taken after the said 6 months, is the company in existence after 6 months? No. Any contract taken in the name of the company after 6 months, it will be as good as it is in the name of Bunty only. And Bunty will be personally liable on that contract. No limited liability concept. Am I clear with this? Understood? Same thing, if it is a public company, 7 members are there, 1 dies. How many left? 6. So this one new member has to be appointed within 6 months. If not appointed, then all the members who are aware of the fact that the company is running with only 6 members will be personally liable. For which contracts? All the contracts which took place after the said 6 months. Within the 6 months, any contract taken, it is in the name of company, limited liability. For all those contracts which have been taken after the said 6 months, for that beta, those members will be personally liable. Am I clear with this? So, writing here, if the number of members fall below the statutory requirement for a period of more than 6 months, members who are aware of the fact shall be personally liable on all the contracts undertaken in the name of company after the said 6 months. Am I clear with this? Everyone? Online students understood everyone? Clear, na? No doubt. Great. So that is section 3A which we finished. Now let's understand the other stuff. Now there are certain important points of OPC which I am telling. Very important points. I am writing here heading important points for OPC. This is only for OPC, okay guys? Let's understand. First, okay, paid. Example guys, I formed a OPC. I am the sole member. Now if I die, will the company die? Will the company die? No, obviously not, because perpetual succession, separate legal entity. But will there be instability in the company? Yes, because I am the sole member and I am not there now. And in order to avoid this instability, it is mandatory only for OPC. If I am forming a OPC, that boss, if I form a OPC, I have to mandatorily appoint a nominee, a person as a nominee, who should give his consent to act as a member in case I die or there is inability from my side to act as a member. So he will become the member. Am I clear with this? So appointing nominee is mandatory in which case? Only in case of OPC. Am I clear? The member of OPC has to appoint a nominee who shall give his consent to be the member in case the member dies or cannot act as a member of the OPC. Am I clear with this thing? Sir, you have to take his consent means there is a format of consent letter. The format is INC3. This is the format of the consent letter. This format you will get it on ROC website also. If you go on the ROC MCA website, okay, INC3 format is there, you have to download it. Am I clear? So it's a PDF. He'll write his consent, sign it, okay, and give it. Am I clear with this thing? Okay. Now, second. Okay, and this INC3 consent letter you have to file along with the form which you file with ROC while forming the OPC. Okay, so that procedure of incorporation and all I'll tell you, don't worry, later on, lesson number 2. Second student asked me, sir, is there any eligibility criteria for being a nominee or a member? Answer is yes. First, the very basic eligibility criteria that the member and the nominee should be eligible to contract. What is eligibility to contract? 3 points we studied in foundation. He should not be a minor, he should not be of unsound mind, and he should not be disqualified by law. That is so basic for every contract. But under Companies Act, is there any special eligibility criteria? Yes. There are 3 criteria. Now in these 3 criteria, there is one point where people have some confusion. People misunderstand that point. So I'll tell you which point. See, in order to be a member or nominee of member of OPC, the person should be fulfilling these 3 eligibility criteria. Which are these 3 eligibility criteria? First, he should be an individual. Hey, what do you mean by individual, guys? Individual means what? Means natural person. Okay, some people say single, committed is also okay, don't worry. Okay, but he should be a natural person. So can artificial persons become member or nominee? No. Second, he should be citizen of India. Citizen of India. Okay, born in India, citizenship he should have. And third is resident of India. What is the third one? A resident of India. What do you mean by resident of India? I'll be called as resident of India this year if I have stayed in the preceding financial year in India for how many days, beta? 182 days or more. Correct? But now this resident criteria is not required because the amendment tells he should be resident of India or otherwise. Now what do you mean by or otherwise? Or otherwise point tells that, boss, if you have not stayed in India in the preceding year for 182 days or more, so you are not resident of India. Correct? So can you become the nominee? Answer is yes, you can become nominee as well as member, but provided you should have stayed in India in the preceding financial year for at least 120 days. How many days? So what people think is resident of India's definition has changed. No, resident of India is still 182 only, but they are telling you are required to be resident of India now, not required as such. If you are resident, well and good. If you are not resident, then too you can become a member as well as nominee, but you should have stayed in India in the preceding financial year for how many days? 120 days or more. Am I clear with this thing? So see, or otherwise means person have or must have stayed in India in the preceding financial year for at least how many days, guys? 120 days. If question comes, your calculation should be on the basis of 120 days. Am I clear with this? Okay. Anyone has doubt here? Once first point again. Yeah, like example, I am forming a OPC and I am appointing you as a nominee. So you should give your consent that in case I die or I cannot act as a member, so you will become the member of the OPC. That is mandatory. But appointing nominee is mandatory only in case of OPC. Forming a normal private company, small company, or a public company, then nominee appointment is not required. Am I clear? Yeah. That is different. Every act has a different definition for residential status. Like in FEMA, it is not 182 days or more. It is more than 182, 183 days or more. So every act has a different definition. My video is stuck. Is it? Data. Now, is it fine? Now, is it fine? No, no. Because I can also see from here. Okay. Great. Okay, understood everyone? Yes. Now, third point. Now, what is the third point? See, sir, at a point of time, guys, if I ask you one question, at a point of time, I can be member in how many companies? At a point of time, I can be member in how many companies? Any number, there is no number. But at a point of time, I can be member in how many OPCs? Answer is 1. I can be nominee in how many OPCs? Only 1. So, I am writing here. Okay. Acha, so tell me before I write, if there is A OPC and there is B OPC, can I be member in both OPCs? No. There is, can I be nominee in both OPCs? Acha, can I be member in A OPC and nominee in B OPC? That is fine. Okay. So see, a person can be a member only one OPC at a point of time. The same applies for being a nominee. However, a person can be a member and nominee in 2 OPCs simultaneously. Am I clear? So, just for example, there is A OPC and there is B OPC. Okay, I'll write it here. No space now. There is A OPC and there is B OPC. Okay. Now, in A OPC, I am the member. And just for understanding, my girlfriend is the nominee. And in B OPC, my girlfriend is the member. And I am the nominee. Harsh. H means Harsh. Nominee. Is it fine? Yes or no? Clear everyone? Anyone has doubt? Anyone? I have a doubt. You know what? If an unfortunate event happens, example, my girlfriend dies. then I'll become the member here, right? So then I am becoming member in 2 OPCs, which is not allowed. So what to do? This is a problem. So this is exceptional situation. For this, law has made some provision. What law tells that, boss, no problem. If this thing happens now, I will get a time period of 180 days to elect any one OPC where I want to be a member. That means there are 3 options, I'll tell you practically. First, I can dissolve one OPC. Second, I can merge the OPCs. And third, beta, I have to elect. I am keeping both the OPCs, but I have to elect in which OPC I want to be a member. So example, I elected to be a member in A OPC. So what I have to do within 180 days, I have to appoint, example, I will appoint my new girlfriend as the member here. Am I clear? Just for understanding, I am not doing all this thing. This is just for understanding. Example, my new girlfriend also dies then. Then again 180 days for new member new girlfriend new member. Am I clear with this thing? Okay. And this is again, don't judge me. Don't judge my character. This is just for making you understand. And I am doing all this to comply the law. Am I clear with this? So 4th point. However, a person can act as a member in 2 OPCs for a period of how many days, guys? 180 days. Clear? Darshan. Video is lagging. Is the video lagging, guys? Online students? No, na. Sudarshan, you just, yes sir. No sir. Just check your internet connections, guys. There is no lag because I also have the screen on. If there is a lag, I'll directly come to know. Okay, thank you. Okay, understood everyone, this part? Okay, now 5th point. Okay, now what is the 5th point? Sir, can a minor be a member in a OPC? Answer is no. In fact, minor cannot be a member in any company, to be fair. But in normal companies, what happens? It is possible that his guardian is a registered shareholder and minor is a beneficial owner. That is okay. But here, minor cannot be a member as well as beneficial owner. He cannot be related to the OPC. Only one member is that also minor. Okay. So, what is the use of that company? So, a minor cannot be a member as well as a beneficial owner of shares in OPC. Am I clear? 6th. Do you remember in small company I told a small company cannot be a section 8 company? Yes, because you cannot take exemptions of both, right? Same thing here. An OPC cannot be formed as a section 8 company. What is section 8 company, guys? Yes, non-profit company. Am I clear with this? In company form not for profits. 7th point. Now what is 7th point? I'll tell you. See, in your book it is written. A OPC cannot be formed as a company carrying on the business of non-banking financial investment activities. In short, a OPC cannot be formed as an investment company. Now what is investment company, you know? Any company's ordinary course of business is to invest in other companies' securities. Example, mutual funds, asset management companies. Why? Do you understand? Because it is their business, ordinary course of business. Sir, why can't a OPC be formed as an investment company? Because there are many reasons. But if I say one of the priority reasons, is that if you want to form a investment company as per incorporation rules, it should be mandatorily be a public company. OPC is which type of company? Private company. So obviously you cannot form it as a investment company. Am I clear with this? So an OPC cannot be formed as a company carrying on the business of non-banking. Might come in your MCQ, this one. Non-banking financial investment activities. Am I clear? Understood everyone? Okay. So more than this also there are some 2-3 points are there, but up till now you understood everything. Clear? I'll give you 1 minute to revise, then I'll show you a question. Then you all people have to solve that question. It's a very good question. Okay. Only 1 minute for you to revise.
Recording stopped.
Can you see the question? Everyone? Or should I zoom in? Zoom. Here you can see. Can you see the question? So see, this is the question. You answer this. Ravi is the owner of a grocery store. In March 2018, he got the idea of forming a OPC and convinced his sister Ruchika, an Indian citizen who resides in London but visits India from time to time, to become a nominee in his OPC. In the year 2017, Ruchika first came to India on 10th January and left for London on 26 February. Thereafter, she again visited India on 7th June and remained here till 10th October and boarded an evening flight on the same day. From then onwards, she did not visit India in the year 2017. But on 2nd January 2018, she came to India for a short duration and left for London on 14th February 2018. Is it possible for Ravi to appoint Ruchika as nominee? Tell me. Now you have to do calculation as of how many days? 120 days. Okay. So you give me the answer. Give me the exact number. How many days she stayed in India? Yeah. Today we'll finish the lesson. I'll send you the note. $218. Okay. Okay. And other answer. One answer I got 218. Call it and How many days? Whether she can be. Tell me. Two hundred and 19 days. Okay. One answer is 218, one is 219. Okay. And so we got two answers up till now. 218, 219. And 171. Okay. Online students. 218. 124. Answer, can she be the nominee? Answer is no. She cannot be nominee. The reason is that she stayed only for 48 days. Sir, how come 48 days? See, bacha party. What is the question telling? When did he form the company? In March 18, Ravi got the idea of forming OPC. So he formed the OPC in which year, beta? March 18. That is which financial year? 17-18. So we have to consider Ruchika's stay in which year? 16-17. Am I clear? So 16-17 starts from 1st April 16 and ends on 31st March 17. This year starts from 1st April 17 till 31st March 18. Now, when did she came India? On 10th January 2017 and left for London on 26th February 2017. That is 48 days if you include both the days. Then she came on 7 June 2017. 7 June 2017 falls in this financial year. So her visit after that has to be ignored only. So she stayed only for 48 days. So can she be the nominee? Answer is no. That's the reason I have put brainy questions. So which all questions will come here will be very technical questions. Am I clear with this thing? Understood everyone? Online people? Huh? Yes. Okay, these are small mistakes which you will do. So paper is never, paper, I'll tell you, CA paper will never be like, what are they asking? I didn't even understand. No. Paper will have understood everything, but one line I'm having confusion. All questions will be like that only. Okay, so people will be tricky, not tough. So, good. Okay, done everyone. Now one question comes. Zoom a bit. Okay, everyone can see the notes properly. Yes. Now, sir, now these are some new points. Why am I not able to write? Is it happening like this? Now, see, everyone can see the notes, right? Now, what is the point? Okay, now the new point is, sir, example, Harsh, I am the member of a OPC. Okay, and my nominee is Munni. Her name is Munni. Okay, she is my nominee. Okay, in OPC. So, can Munni withdraw her nomination? Still, I don't want to be with this Harsh. I want to be with Mr. Chulbul. Okay. So, can she withdraw her nomination? Yes. Question is can. she withdraw her nomination? Answer is yes. But she has to do one thing. You know what? Okay, Munni has to inform whom, the member Harsh and the OPC plus whom beta OPC. Okay, that I am withdrawing. Now what Harsh has to do? Harsh has to appoint a new nominee. Yes or no? Appoint a new nominee. Okay. Example, I appointed a new nominee. Okay. Her name is Sheila. What is her name? Sheila. Okay. Within how many days beta I have to appoint, and inform? Harsh has to appoint new nominee Sheila. Okay. Plus inform. I have to inform whom beta? Inform the OPC. Within how many days beta? Within 15 days. How many days beta? 15 days. Am I clear with this thing? So the day when I understand that she is withdrawn, I have to appoint a new nominee and also inform the OPC within how many days? 15 days. Am I clear with the first one? Yes? Okay. Now second, see here Munni ditched me. Can I ditch Munni? Yes or no? So, okay, same thing. Can Harsh change nominee? Can I change nominee? Yes. Answer is yes. But here what I have to do now? Okay. When Harsh, I change the nominee. I have to appoint. What I have to do beta? Appoint new nominee. Appoint new nominee. Okay, and inform whom beta? OPC. Within how many days beta? Same, 15 days. Same here. I change my new nominee. Who's the new nominee beta? Okay, Sheila. Who's the new nominee? Sheila. Sheila is the new nominee. Am I clear with this thing? Clear everyone? Yes? Okay. Now third case, see, I ditched Munni. I did a bad thing. Okay. So God punished me. In the third example, I died. So if I die, who will become the nominee? Sorry, who will become the member? Who was my original nominee? Munni. है ना? So Harsh died. Okay. In that case, Munni shall become member. But now beta, just imagine she became the member, so she has to appoint a new nominee also, no? So she also has to appoint a new nominee. They can inform OPC within how many days? 15 days. So here Munni has to appoint new nominee. Who is she appointing new nominee? Chulbul. Am I clear with this thing? Okay. And inform OPC within how many days? 15 days. Am I clear with this thing? Now understand, in case 1, case 2, case 3 beta nominee is being changed or not, and we informed whom ultimately? OPC. Now to the last point which tells, sir, what should OPC do? So OPC, okay, in all scenarios, scenario 1, 2 and 3, okay, has to inform whom beta? ROC, that was there is a new nominee. Okay, ROC within how many days? Within 30 days. Within our 30 days. Sir, in which form? In form. There is a E form. INC4. Which form beta? INC4. Am I clear with this? Understood properly? Clear everyone? Yes. So this is what OPC has to do. Clear? Right. So this was everything about OPC. a very important point, big probability it will come in your exams. In foundation, so I'd say every 100%, but here also 90% probability it will come in your exams. Am I clear? Or anyone has doubt? No, no. Okay, so we'll do some questions from our book also. Okay, you people answer that. Very simple questions. See, question number 5. Everyone can see that question or zoom in? I should zoom in. Okay, now it's fine. Okay. Question number 5, you people tell me the answer. Mr. Aditya had incorporated a one-person company on 7 July 2021. Mr. Yash was named as nominee in the memorandum of said OPC. Yash. Okay. Now Aditya, considering the perpetual nature of company form of business, desires to appoint ABC Private Limited as nominee. Instead of Mr. Yash, he wants to change the nominee. Aditya wants to. Examine with reference to Companies Act whether the proposal of Aditya to appoint ABC Private Limited as nominee is valid or not. No. Why not? Yes, because boss, if you want to be a nominee, you need to be natural person. Here, beta, okay, ABC Private Limited is obviously not a natural person. It is an artificial person, so it cannot be appointed as nominee. Am I clear? Yes. Wow, wow. Sir, so simple. Yeah. Third point, yes, I'll explain. Don't worry. In OPC and member are same person or separate entity, re company, it's a company, Akshata. Separate legal person in the eyes of law. Not a sole proprietorship. Okay. You joined late or what? Some people joined late, I know today. Yes, great. Correct. Okay. I hope I'm clear. So we have here officially completed classification of company. Do you remember we started classification of company on the basis of members? Public company, private company. In private, no, small company, OPC. Clear? Yes? Great. Now the next classification is classification on the basis of what, beta? Third one, classification on the basis of control. Okay, on the basis of control. One company controlling another company, on that basis. Okay, classification is there. Now, which are the three companies here? Pay attention properly. First is holding company. Which company, beta? Holding company. Second is subsidiary company. Okay. And third is associate company. I'll give you examples also. Associate company. Okay. Holding company, subsidiary company, associate company. Sir, what I'll tell you in relation, practical relation. Holding means papa company, subsidiary means bacha company, associate means brother sister company, siblings. Papa, bacha, brother sister. Am I clear with this thing? Now, what is holding company? In general terms, people say it is a parent company. We don't say it parent. We say holding because we are professionals. Yes or no? So, what is holding company? Section 2, clause 46. What is the definition? Section 2, clause 46. Basically, what is the definition given, in as section 2 clause 46? Holding company means the company which is holding in relation to the subsidiaries. Hey, what nonsense. I have simplified it. Okay, holding company means a company which has subsidiaries. Which has subsidiaries. Subsidiaries. Okay. That means if my company has subsidiaries, then in relation to that subsidiaries, I am the holding company. When can I be called as Papa? When I have bachas. Without bachas, can I be Papa? No. Okay, I can be daddy, but not Papa. Okay. Now, so simple, no, nothing confusion. Okay, so holding company means a company which has subsidiaries, and in relation to the subsidiary, it is holding. But subsidiary company definition is beautifully given. Very beautiful, very beautiful. Section 2, clause 87. This point tells that a company can become subsidiary of another company in 3 ways. And how many ways, beta? 3 ways, 3 methods. That means you can have bachas in 3 methods. By 3 method. Arey bhai, bachas means in relation to law subsidiary. Don't enter any other zone. Okay. Bas. Okay. So when can a company become subsidiary, or when can I call a company as a subsidiary? Okay. So there are 3 methods. Now which are the 3 methods? I'll tell you. Wait. Sections are mandatory to write in exams. Section definition section 2 are definite. That you write. Other sections, I am telling it, if you want to be rank holder, see, rank holders have to do something extra which others are not doing. Like example, if you write, I am telling you, if you don't write section, so every question half mark will be deducted. So example, there are 15 questions, 16 questions, so 7 to 8 marks are deducted. But if you write the sections properly, you get 8 marks extra, 8 to 10 marks extra you will get. Now every paper, if you score 8 to 10 marks extra, so it is 50 to 60 marks extra than the other people, and this 50 to 60 marks extra will get you a rank. So for a rank, small extra things they are doing. They are not like if you are not a rank holder and rank holders are genius. Okay, no, they have put some extra efforts. That's it. Am I clear? Understood, Noor Mohammed? Okay, so it's not mandatory, but it is always advisable. Okay. And when you tell, I always feel this thing, like if you know, like if I'm a faculty, just imagine I say, I don't know the section number. How it feels very odd, right? So if I'm a faculty, I'm a professional, I should know the section number. Same thing when you are a chartered accountant, when you sit in front of the client, boss, you should know section number. If he asks anything, if you're like, yes sir, we have a solution to this as per section 3A. So he'll be like, oh boss, yeah, CA, my CA. Yes or no? It's like that. Okay. So see. Now, see, subsidiary company. Now, what is subsidiary company? So, subsidiary company, it is telling this point tells that one company can become subsidiary of another by 3 ways. So, see, subsidiary company means a company in which another means holding company, another company. First method, A point, controls the composition of board of directors. Controls the composition of board of directors. So example, A limited is there, B limited is there. If A limited controls the composition of board of directors of B limited, then A limited is the holding company and B limited is the subsidiary. Very simple. But sir, what do you mean by controls the composition of board of directors? See, as a professional now, you cannot just read. I told you first lecture, you cannot just read and go. You have to definitely and exactly dead sure about what is written here. You should be dead sure. So what do you mean by controlling the composition of board of directors, sir? What does that mean? How many directors they have there? Majority or all? Majority. Okay, now I'll ask you one more question and I know what answer you will be giving. Challenge accepted? Okay, generally now I write on paper, this is what you will answer. I know what answer you will give. Okay, so see, so I'm writing here, what do you mean by controlling the composition of board of director? It means power to appoint as well as remove majority of directors. How many directors beta? Majority or all, but which majority is written, what is written, what is given. Now the example A limited is there and B limited is there. Example B limited has 10 directors. How many directors? 10 directors. Now if A limited has the power to appoint as well as remove how many directors in this case? 6 or more directors. Then A limited becomes the holding company and B limited becomes the subsidiary company. Am I clear with this? Understood? Ajay, guys, you tell me, how will A limited or any company get power to appoint as well as remove majority of directors? How will one company get the power? Online students, you can also answer. How will one company get power to appoint as well as remove majority of directors? I know what answer you'll give. When they hold majority of shares. Okay. And online students, holding more shares more than 50%. Yes, I know, but this answer will come, but it is wrong. You know why? See, logical I'm telling you. If you want to appoint directors are appointed in members meeting. Okay, finalized in members meeting. And for appointing director, ordinary resolution is required. What do you mean by ordinary resolution? Majority of votes are required. How many votes? Majority of votes. So if A limited has majority of shares, basically majority of votes in B limited, okay, does it have the power to appoint majority of directors or all the directors? All the directors, na, because without their consent no director can be appointed. So if you are telling the majority of shares they hold, then it is not majority of director, it is all directors they can appoint. Did you understand? So how does one company get power to appoint majority of director? It is generally by finance agreement, loan agreement. Like we had done in one of the company, we had raised 100 crore rupees from the bank. We had taken loan from a bank, ICAI Bank. ICAI Bank gave a condition that until the loan is repaid, so there will be 11 directors appointed on the board. In the future lessons, I'll tell you how we raise that money also. Out of 11 directors, okay, 8 directors will be appointed by ICAI Bank until the loan is repaid. And 3 directors minimum for public company will be appointed by the company's members. So basically tell me, is our company, was ICAI Bank holding company of our company or not? Am I clear with this? Understood? Clear everyone? Yes? Okay. So that is by finance agreement. Clear everyone? Generally it happens by loan agreement only. Okay. Understood? Okay, this is the first method. Now we'll do the second method. Okay, I finished the page here. So the second method I'll write on another page. Just a second. Everything is easy, no? Just have to understand the concept. Now the second method, I'll write it here, B method. Okay. One company, a subsidiary company means a company in which another company holds together with its subsidiaries more than one half of the voting rights. Now understand this thing. More than one half of the voting rights means we do the calculation on one equity share, one vote. So in the question they might not give you A Limited is holding this many voting rights, votes in B Limited. They'll give A Limited is holding this many equity shares in B Limited. So one share, one vote is there. Am I clear with this thing? So if they have given equity share, it is corresponding to the vote only. Okay. So here I am writing here one equity share is equal to one vote. But they play smart also. Huh? They will give you question. This company is holding this many equity shares in this company and this many preference shares. Are you required to consider preference shares or you have to ignore? Ignore. Because only equity shareholders have voting rights. If they'll also confuse you maybe. Will your answer differ if the preference shares are convertible preference share which will be converted into equity? Then too you have to ignore. It is only equity share. Actually, you know why? Because only equity shareholders have voting rights. Actually, initially what was the statement here, you know? He holds together with its subsidiaries more than one half of the paid up share capital. But they changed it in Companies Amendment Act 2017 because yesterday we studied there are companies having share capital, not having share capital. Do you remember company limited by guarantee? Not having share capital. So those members will get voting rights on, maybe that will be written. Any member who has guaranteed 100 rupees will get one vote. Okay, so 1000 rupees if you have given guarantee 10 votes. So members of a company having share capital, not having share capital, both have voting rights. And that is the reason quantification is done now on voting rights, not on paid up share capital. Because if it is done on paid up share capital, you cannot consider holding subsidiary by second method for a company not having share capital. That is the reason it is now voting rights. Am I clear with this? Understood everyone? Okay. Very good. And C is very simple. Subsidiary company. For this example, I have to write. Very simple. Example A Limited is there and B Limited is there. B Limited has issued 1000 shares. Indirectly, how many votes, beta? 1000 votes to its members. And if A Limited holds how many shares, beta? Wrong. I knew you'll say 51. It is majority, not 51. 51 and majority is different. So easy here it is basically if A Limited holds 501 shares, 51 will be 510. So 51 shares, indirectly 501 votes in B Limited. Then A Limited is the holding company and B Limited is the subsidiary company. Am I clear? Everyone? Yes? Okay. Now C point. Now what is C? C is very simple. Subsidiary company of original subsidiary is also the subsidiary. In the module it is given technical. The first mentioned company is a subsidiary of that other subsidiary. This is the meaning is same. Subsidiary company of original subsidiary is also subsidiary. Very simple. Understand. A Limited is the holding company of B Limited. So B Limited becomes subsidiary. But if B Limited is the holding company of C Limited and C Limited is the subsidiary, the question is there. So can I say is C Limited subsidiary of A Limited? Yes or no? Yes. Very simple. Answer is yes. Clear? Say I bow down to my father. My father bows down to his father, grandfather. So won't I bow down to grandfather? Yes. So who's the original holding company, ultimate holding company? Grandfather. Am I clear with this? Everyone understood? Properly? 3 methods. Okay, just revise the three methods. Okay, I am drafting a question and answer. Okay. Online students, anyone has doubt? Key point, very simple. A Limited is the holding company of B. B is the holding company of C. So basically A Limited is the holding company of C Limited. Simple. Simplest point. Understood? Because we are studying on the basis of control. Now A is controlling B, B is controlling C. So who is indirectly controlling C? A. Okay. Everyone understood? So we'll do one question. We'll make one question. My question is, and one question I have to ask on the basis of OPC also. My question: A Limited holds 35% of shares or voting rights in B Limited. Voting rights. A Limited holds 70% of voting rights in C Limited. Okay. And C Limited holds 17% voting rights in B Limited. Question is B Limited subsidiary of A Limited? Yes or no? If the answer is yes or no, I'll explain B point, don't worry. Yes or no? Answer is yes. Okay. Answer is yes. But by which method? By method first, second or third? A, B or C? Which method? Huh? Answer is method B. Now people who have in mind method C, they are wrong. Because many people give me a method C. Why it is wrong? The reason I'll tell you. See, when will C come? C method come. A is the holding of C. C is the holding of B. Then method C will come. Is C the holding of B? No. But why will B come? The reason is that, beta, what we studied, see, if A Limited holds together with its subsidiary along with C more than one of B. So here tell me, A Limited subsidiary C. A along with C is holding how much, beta? A is holding 35, C is holding 17. So A along with C is holding how much? 52%, majority of voting right. So answer is yes. So this method is yes. By method. Am I clear with this? Am I clear? Everyone? Sure. Okay. So somebody had doubt in point B. Point B tells that if A Limited along with its subsidiary holds majority of shares in a company, in this case A is holding 35, A's subsidiary C, C is holding 17. So A along with C, A plus C is holding how much? 52% in B. So A is the holding company of B. Am I clear? Okay, great. So we have done holding and subsidiary. I hope understood. I hope everyone understood holding and subsidiary. But in holding and subsidiary, there is some important concept. Section 19 has been given, which was not there in your foundation. Okay, so pay attention properly. Okay, but before that, if I ask you one more question of OPC, I'm putting a question. See the question, then we'll again come back to holding subsidiary. It's a beautiful question. CS Executive 3 marks. An OPC can be a company limited by shares as well as a company limited by guarantee. Tell me, true or false? And if I'll be happy if you give me the reason also. An OPC can be a company limited by shares or a company as well as a company limited by guarantee. Think can answer. True. Which one? Which one, Akshata? Huh? True. How many people said true? True. False. Answer is true. Why, sir? True. See, it's a very simple answer. Yes, yes. Perfect. Perfect, Sanya. The answer is true. You know why? OPC. What is the full form of OPC? One person company. One more time. One person company. And company, do you remember classification of company? A company can be company limited by shares, limited by guarantee. It can also be unlimited company. Am I clear with this thing? That is the reason answer is. If the same question comes for 3 marks, you have to write what is OPC definition, and you also write how to classification of company on the basis of company limited by shares and limited by guarantee. And then you have to conclude key as it is a company, it can be a company limited by shares as well as company limited by guarantee. Clear everyone? Yes, great, great, great. If you can answer these questions now, I'm telling you can easily score 70 plus because these are tough questions. These are tough questions. These are all tough questions. If you can answer this, boss, 70 plus guaranteed. So, clear? Yes. Now, now we were studying something important of holding and subsidiary. Okay. So I am writing here section 19. Anyone has question? Anyone has questions? Any doubt? Online students? No? Great. Now see what is section 19 tells. One of the favorite question of ICAI. Like when we were giving exams was we used to by heart this and go because we knew every alternate item it used to come. See, question is my first question. Guys, tell me, can I be a member in a company? Yes or no? Can you be a member if you are a major? Yes. Can one company be a member in another company? Yes or no? Yes, my investment companies and all are there. So, can a company be a member in another company? People who want example of holding subsidiary, there is many examples are there. Take a Tata Jaguar. Tata is the holding company of Jaguar. Tata Sons is the holding company of the whole Tata group. Tata TCS, you say anything. Tata Industries Limited. Okay, like that. Can a company be a member in another company? Answer is yes. But there is section 19. What does it tell you? No, a subsidiary company cannot hold shares of holding company. It's quite logical. Holding company puts money in subsidiary. Subsidiary with that money again buys shares of holding company. What nonsense. And so subsidiary company, however, as per section 19, a subsidiary company cannot hold shares in its holding company. Am I clear with this? But tell me, are all my 5 fingers same? No. So obviously all the 5 situations will not be same. So you cannot draft any law without exceptions. So there are 3 exceptions. That means in these 3 exceptions, a subsidiary company can hold shares of its holding company. So which are the 3 exceptions? But there are exceptions. These are exceptions to section 19. First exception, let's understand. First exception. A subsidiary company can hold shares of its holding company as a legal representative, as a legal representative or nominee of the member of holding company. Sir, what does it mean? I'll tell you. See, understand. Example, Mr. Nagarjun. Nagarjun. Okay, you know the actor. It is not his case, but I am just telling. Nagarjun. He is holding 100 shares. Okay. In A Limited. Which company, beta? A Limited. Okay. Now Nagarjun has his own company, B Limited. Okay. Now understand, A Limited is the holding company, B Limited is its subsidiary company. There is holding subsidiary relation. Now what Nagarjun writes in his will? Okay, Nagarjun writes in his will. Okay, he makes a will, and in his will he writes, after my death, that is after, not my death, Nagarjun's death. After Nagarjun's death, these 100 shares shall go to which company? Go to his own company. Which company, beta? B Limited. Am I clear? Understood? Now Nagarjun died. So basically now A Limited's this 100 shares will go to whom, beta? B Limited. And B Limited is holding the shares as what, beta? Legal representative or nominee of Nagarjun. So can B Limited subsidiary company hold shares of its holding company in this way? Answer is yes. Clear is this. Understood? Clear? Second example. A subsidiary company can hold shares of its holding company as a trustee. As what, beta? Trustee for a beneficiary. For a beneficiary. Let's understand this thing. What is this? See, A Limited is holding company and B Limited is subsidiary. Same example, a bit twist here. What is that twist? Same A Limited's 100 shares are held by whom, beta? Mr. Nagarjuna. Nagarjun. Okay. And Nagarjun has a son. His son name is, he has a son named is Chotu. What is his name? Chotu. So Nagarjun writes in his will, same, कि after Nagarjun's death, all the 100 shares, these shares shall go to whom? Shall go to Chotu. Arey, but Chotu is how many years old? Chotu is 8 years old. Can he be member? No, he cannot be shareholder. He is not competent to contract. So he writes something else also. He writes until majority of Chotu, the shares will go to whom? Will go to B Limited, and B Limited will hold as what, beta? Trustee. Trustee for whom, beta? Chotu. Yes or no? So here B Limited, after Nagarjun's death, if Chotu is still a minor, will hold the shares of its holding company, but as what, beta? Trustee for a beneficiary. Who's the beneficiary, beta? Chotu. I am writing his. This is also possible. Am I clear with this thing? Yes. Everyone. Now the C point. This is important, interesting. Third method. 3 exceptions are there. There are 3 exceptions. This exemption you will easily understand. A subsidiary company can hold shares of its holding company which it purchased before becoming subsidiary. Before becoming subsidiary. Did you understand this point? Like A Limited is there, B Limited is there. Before B Limited became subsidiary of A, B Limited had purchased some 10 shares. After a year, beta, A became the holding of B. Can B Limited still hold that 10 shares? Yes, that is allowed. But tell me, beta, now understand, as a shareholder, forget share, as a citizen of India, which is your biggest right? As a citizen of India, which is your biggest right? Perfect, right to vote. Yes or no, online students? And that's the reason, beta, similarly as a shareholder, which is your biggest right? To vote. So in the C case, only in the C case, in this case, C case, okay, subsidiary will hold shares of holding company, but on that shares it will not get any voting rights. You know why? Arey, subsidiary is bacha. Can bacha tell papa what to do? Just imagine you, now up till now your father is holding the finances and he's telling how to run the show. Now imagine, beta, you became a chartered accountant, and now you are handling the finances and you see your dad sleeping till 8 o'clock. Can you say, Dad, from tomorrow I don't want you to see you sleeping till 8 o'clock. I'm running the house now, I'm running the finances. Okay, from tomorrow get up at 6 o'clock. What will dad tell? Where is my chappal? Yes or no? Can you tell your dad what to do? No, obviously not. Okay, so here the subsidiary company shall not be entitled to any voting rights. Only in the C case, third case, any voting rights. Now, how can you do it? Now, holding company will vote in subsidiaries. No. Now, and after that, what is written? Very important. After a company becomes subsidiary of another company, na, you know, have you heard about bonus issue? Free of cost shares are issued. Right issue. Company offers shares only to existing members. So any allotment, in this way, they allot the shares. But holding company is there, subsidiary is there. Once a company becomes subsidiary, holding company, whenever it does bonus issue, right issue, it allots shares. It will allot shares to all members except to whom, beta? Subsidiary company. For subsidiary, beta, you will never allot any share because section 19 does. Subsidiary company cannot hold shares of its holding company. It cannot take shares of its holding company. Am I clear? Practically, I'll tell you, no, practically in second method it is allowed because in second method the company is holding as a trustee. So it will get beta bonus shares, right shares. Okay, but in the book nothing is written, so I will study as per the book. Okay, after becoming subsidiary, any allotment of shares by the holding company to subsidiary is void. Am I clear with this? Clear? Understood everyone? Online students? Any further allotment of shares by holding company to its subsidiary company shall be void. So these are the 3 exceptions. So can a subsidiary company hold shares in its holding company? No. But which are the 3 exceptions? First, it can hold shares as legal representative. As what, beta? Legal representative or nominee of the member of holding company. Second, it can hold shares as what, beta? Ticket trustee for a beneficiary. And third, beta, whatever shares it purchased before becoming subsidiary, it can still hold that share. But on that shares, beta, no voting rights will be given. Am I clear with this? Everyone? Sure. Now some people have one question because there is a line given in the book. People ask me, sir, Like A Limited is subsidiary, is holding, and B is subsidiary. I'll write it here. A Limited is holding of B Limited. Okay, this is not section 19, this is separately given. So this is first layer of subsidiary B Limited. B Limited has a subsidiary C Limited. This is second layer. Like this, how many layers can there be of subsidiary? Answer beta. See, there is one word which people miss. There can be n number of layers of subsidiary, but there cannot be more than 2 layers of investment subsidiaries. This word is written, investment subsidiary, in section 186 particularly. When you go in CA final, we'll study that. Investment subsidiary means beta, if B Limited is a investment company. In that also many exceptions are there. Investment company means its ordinary course of business is to do investment in other companies like mutual funds. Okay. C Limited also is an investment company. So there will be 2 layers of investment company. Now there is D Limited, subsidiary of C. Now D Limited is a normal company. Acha, it is an investment company, example. It is also investment company. So can there be third layer of investment company? No, not allowed. But it is a normal subsidiary, not an investment company. It is not an investment company. It is a normal company. So can there be third layer? Yes. So there cannot be more than 2 layers of investment subsidiaries. Normal subsidiaries, yes. Am I clear with this? एक छोड़ के एक भी हुआ, like if there is one leaving one alternate, then to beta layer is counted na. Only 2 layers. Am I clear with this? Understood? Here. Okay. So this is just a point for you to remember. Okay, they won't ask you questions from this because this is CA final ka question. Clear everyone? Yes. One more thing, in your book it is written. Example, A Limited is the holding company and B Private Limited is the subsidiary company. So B Private Limited is a private company which is a subsidiary of a public company. So a private company which is subsidiary of public company is a deemed public company. What we call beta? Deemed public company. Sir, what do you mean by deemed public company? Now understand the concept. See, this B Private Limited, as per the AOA, 3 restrictions will be there. It is a private company only. But I told you yesterday, last lecture, the whole Companies Act is made on the basis of public company. Private companies get exemption. But this B Private Limited will be for the purpose of complying Companies Act, will be deemed to be a public company. So will it get any exemptions of private company? It will not get exemption. It has to follow all the rules and regulations of public company. Am I clear? This is the meaning of deemed public company. Clear everyone? Okay. But yes, if example A Private Limited is holding and B Limited is a subsidiary. Public company is a subsidiary of private company. So will that public company be deemed a private company? No. Vice versa is not allowed. Am I clear? Everyone? Yes? Good. So we have finished holding and subsidiary. But we have to solve questions also. Should we solve questions now? Yes, great. Online students, anyone has doubt? Anyone has doubt? Online students? There is no. If you understood everything, just give us thumbs up. Give a thumbs up. No doubt now? Everyone? You know how to give thumbs up? I hope you know how to give thumbs up. Yes. Deemed public company. Yeah, I'll explain, no problem. See, A Limited is holding company, B Private Limited is subsidiary company. So private company is the subsidiary of holding company. So we call that private company deemed. Deemed means assumed public company. So as per the AOA, take a 3 restrictions of private company, everything will be there. But what all exemptions private company get from Companies Act? I told you the whole Companies Act is made as per public company. So public company has to follow the whole Companies Act. Private company gets exemption. Don't follow this section. Don't follow this section, like that. So now this B private limited, will it get the exemptions? No, because it is assumed to be a public company. Am I clear? Understood? You know why? Because now what I'll do now, example, if this point is not there, I'll form a public company and I know there are many exemptions I'll not get. But if I had been a private company, I would have got the exemption. Now I can't get the exemption. So what I'll do now, I'll form a subsidiary company. Put all my money in the subsidiary company, and via the subsidiary company I'll take exemption and do that thing. So it's a fraud, yes or no? It's a loophole. That is the reason. Am I clear with this thing? Okay. Like example, one example I'll give you. In Companies Act 1956, old act, if a public company is giving loan to director, then members approval is required, special resolution. But private company, it is not required. Now I'm a director, I want loan, but I know my members will not allow. I'll form a subsidiary company, put money in the subsidiary company, and through in subsidiary also I'll become director, and through that subsidiary I'll take loan. Did you understand? So now beta, if this point is there, so in that subsidiary also, my subsidiary is a private company, there also beta I have to take whose approval? Members approval. Am I clear with this? Just to cancel the loopholes. Clear? Everyone understood? Great. Now we'll do questions. Understood. The third question, Kapila Limited. Let's start solving this. Kapila Limited issued equity shares of 1,10,000 shares of 10 each on 1st April 2021, which have been fully subscribed, whereby Kusha Limited holds 4,000 shares and Prem Limited holds 2,000 shares in Kapila Limited. So we understood beta, Kapila Limited has issued how many shares beta? 10,000 shares. Out of that 10,000 shares, Kusha is holding how many shares? 4,000, and Prem Limited is holding 2,000. So together they are holding more than 50% of the shares. Good. Kapila Limited is also holding 20% equity shares of Red Limited before the date of equity shares as above. Okay, so Kapila is holding 20% shares in which company? Red Limited. Okay. Red Limited controls the composition of board of directors of Kusha Limited and Prem Limited from 1st August. Okay, so basically Red Limited is controlling the composition of board of directors of Kusha and Prem. So can I say that these two are subsidiaries of Red Limited? Yes, no? Everyone understood? Examine with relevant provisions of Companies Act whether Kapila Limited is subsidiary of Red Limited. Answer is yes. By which method beta? Method 2. See, Red Limited along with its subsidiaries is holding more than 50% of the shares of Kapila. So basically Red Limited will be the holding company. Method 2. Am I clear? Understood? Everyone? Achha, I think in one example I wrote something by mistake. I wrote one. This question. No, either method B. Method B. Okay, I wrote by mistake method C. Okay. Understood? Okay. Here also method 2, or you can say method B. Whether Kapila Limited can hold shares of Red Limited. This 20% shares, can it hold of Red Limited? Yes, because under which section? Section 19, third exception. Subsidiary company can hold shares of its holding company which it purchased before becoming subsidiary. Okay. So this is section 19 exception. Am I clear with this? Understood? Everyone? Clear? Online students, anyone has doubt? Okay. Okay. Anyone has doubt in this question? Online students? No doubt? Great. One more question. Okay. Vrijesh Limited is a company in which Rishikesh Limited is holding 60% of its paid up share capital. So I'll write it here. See, always make diagrams. Diagrams will help you. So Rishikesh Limited is the holding company. Is the holding company, and Virjesh Limited it is. Virjesh is subsidiary. Okay. Okay. One of shareholders of Rishikesh Limited made a charitable trust. Example, Mr. X is the member of Rishikesh Limited. He made a charitable trust. Example, X Trust. And donated his 10% shares of Rishikesh Limited and 50 crore to the trust. Oh my god, rich man. So whatever shares, example, he had 100 shares. Out of that 100 shares, 10 shares he gave to X Trust, okay, plus 50 crore rupees. Yes or no? Now, and he appoints Virjesh Limited as trustee. Now, Virjesh Limited is the trustee, okay, of X Trust. So, who's holding this 10 shares and 50 crore? Virjesh Limited. Okay. All the assets of the trust are held in the name of Virjesh Limited. Can subsidiary company Virjesh Limited hold shares in its holding company in this way? Yes or no? Yes. As per which exemption? Section 19, second exemption. The subsidiary company can hold shares of its holding company as a trustee for the beneficiary. So Virjesh Limited is the trustee and beneficiary is X Trust. Am I clear with this thing? Understood? Perfect. Online students? Clear? Online students understood properly? Yes? Okay, so we have finished holding company, subsidiary company properly. Okay, one associate company point is left. We'll do it. Okay, 5 minutes break now. Okay, so great. I hope no doubt. 5 minutes break we'll take and we'll continue. Okay.
Recording stopped.
Okay. So we had completed holding company and subsidiary company. One company was left, which is the third part, that is associate companies. So I'll write it here. I think you have made the bracket already. Okay. So associate company. Associate company. Now, what is the section for associate company? Section 2, clause 6. Which section? Section 2, clause 6. Now, what is associate company? See, understand guys. Now, pay attention here first. How it is written? Beautifully it is written. Associate company means which company? If one company has significant influence over another company, both are associates. If one company has significant influence over another company, both are associates. Sir, what do you mean by significant influence, sir? Okay, legally I'll tell you, but generally, do you remember I told holding subsidiary associate? Papa, bacha, brother, sister. Why did I say brother, sister? There was a reason for that. See. What do you mean by significant influence? Significant influence means, beta, if one company can significantly affect the decision making of another company, then both are associates. Like online students, just tell me, raise your hand also, and you people also can tell that how many of you have siblings at home opposite gender? 1, 2, 3. Siblings at home opposite gender. Sudarshan, Neela is there. Yes? Yes, you have opposite gender. Okay. So if I ask Neela, okay, you can tell me. Neela, you have brother, younger or elder? Just let me know. Elder. How many years elder? 3 years. Do you fight with him? Yes, na. And I am very sure there would not be, if I ask you why do you fight, you will not find a reason. For siblings, beta, especially brother, sister, there is no reason required to fight. Yes or no? Actually, I say, beta, brothers, they do fight, but not that much. Sisters also do fight. But after a level, beta, they stop it. After an age, brother, sister, my God, they are at a different level altogether. Yes, I have seen this thing. Like, I have a brother. We used to fight. And I used to hate my brother. You know, in childhood, you used to literally hate that person. But then I went to stay with my cousins. My cousins, they are brother sisters. Sister is elder. At that time, obviously, they were small. She was 2 years elder. And as at that age, if your sister is 2 years elder, she can literally beat you. She used to beat him. And this guy named as Nikhil, he can't beat her back. So what he used to do, he used to bang his head on the wall. Kill me, kill me, kill me. And every half an hour they are fighting. When I'm going for sleeping, at that time I see him banging his head. When I'm waking up, I see his banging his head. After that, I felt my brother is so good. Yes, such a genuine human being. So brother sisters fight a lot. But Neela, all other people, tell me, in case your family is planning a picnic somewhere, and on the same very day, your sibling has an exam or something which he cannot evade or she cannot evade, would you continue the picnic without them, or you want them with you? You want, right? Correct? Yes, Neela, you want, right? So can I say your sibling has a significant influence over your decision making? You will shift the date. So you both are associates of each other. Did you understand? Am I clear? So sir, that is okay, understood, general reason why significant influence. But is it quantified like holding and subsidiary? In holding subsidiary, majority of shares was there, voting rights was there. So here is it quantified? Yes, here also it is quantified. But let me write the first part here, then we'll see the quantification. Associate company means a company, if I'll write like this, if a company has significant influence over another, both are what beta of each other? Associates of each other. Now first thing, sir, why are we studying associate company? Because now at this time we will not understand the importance. When we will do lesson number 9, consolidation of financial statements, at that time associate word is very important. That time you will understand it. Now sir, what do you mean by significant influence? I'll write it here, significant influence, downside. Significant influence means a company holds 20% or more. How much? 20% or more, but not more than 50% of what? Of voting rights or paid up share capital or interest in another company. Or what beta? Interest. If one company holds 20% or more, like example, if A Limited holds 20% or more, but not more than 50% of voting rights in B Limited, paid up share capital of B Limited, or interest in B Limited, then both are associates. Sir, why 20% or more but not more than 50%? Because if it is more than 50%, then beta holding subsidiary relation will start. Am I clear with this? Like generally, if you are the younger sibling, or if you are the elder also, like you tell something to your sibling to some extent, he will listen or she will listen. If you try to control more, what they'll say, don't try to become my mother. Yes or no? So you are associates, you are not holding company. Am I clear? That is the reason, 20% or more, but not more than 50%. Now, something important here. See, sir, when we say paid up share capital, so I am writing here, in paid up share capital, you have to consider equity plus convertible preference share capital. Here equity plus convertible preference share capital both have to be considered. But in holding subsidiary only equity. Am I clear with this thing? Everyone? Yes? Okay. Sir, interest. What do you mean by interest? See, if A Limited and B Limited is there, if A Limited can appoint more 20% or more, but not more than 50% of directors in B Limited, so basically they are associate. That is interest. One more example I'll give you of interest. Pay attention. and write it here. Interest. Example: A Limited, B Limited, C Limited, D Limited. They formed a JV, joint venture. Have you heard about joint venture? And that joint venture is E. E Limited is joint venture. Okay. Now, if beta whatever profit comes, 20% or more, but not more than 50%, 20% or more of the profits will go to A Limited. So, is A and D associates or of each other or not? Yes, that is interest. Or 20% of the assets of E Limited will be owned by whom beta? A Limited. Okay, so it is 20% or more. So then too it is interest. Am I clear with this thing? Did you understand example of interest? If you 20% or more of profit is being taken by A Limited, or 20% or more of the assets of E Limited is owned by A Limited. Okay, so that is also interest. Now I'll give you example of associate companies. Examples, Reliance Industries Limited, Reliance Industries Limited, Reliance Infrastructure Limited. Okay, both are associates. In Reliance Infrastructure Limited, 45% of the shares of Reliance Infra is held by whom beta? Reliance Industries. So they both are associate. One more example, Reliance. Have you heard about this Balaji Telefilms? Old Balaji, है ना? ठीक है, एकता कपूर, एकता कपूर, क्योंकि सांस भी कभी बहू थी. Yes, Balaji Telefilms. Okay, they are also associates of each other. 25% of shares of Balaji is held by Reliance, and that's the reason you might have seen. See, in Old Balaji app, you will find movies owned by Jio Cinemas. Generally, in Jio Hotstar, the movies should come na Jio owners. But beta Jio, the movies owned by, produced by Reliance. Okay, that is Jio. Basically, Jio Cinemas will also be telecasted on Old Balaji because they both are associates of each other. Am I clear with this? Understood properly? Clear everyone? Yes. So these are associates. How much beta? 20% or more, but not more than 50%. Clear? Online people, everyone understood? Yes. Sure. Anyone has doubt? Yes. Voting rights in paid up share capital, equity plus convertible, both you have to consider. So here we have completed beta. What is holding company? What is subsidiary company? What is associate company? Am I clear with this? Everyone? Yes. Give me a thumbs up if you have understood. Everyone, online people, give me a thumbs up. Perfect. Great. Okay. So we have completed classification of company on the basis of what beta? Liability of members, on the basis of members, on the basis of control. Now the next one is on the basis of what beta? Capital. Okay. Classification of company on the basis of capital. Beta, classification of company on the basis of capital na I am writing here, will do from JKSC book only. I'll show it to you. Okay. You want to take a screenshot now, you can take. Anyways, we will be sending. Did you get now the book? No? You got it? That first lesson wala. I don't think you received it. First you are not, na? I'll send it to you. Don't worry. Okay, great. I'll send it to you. Today itself you'll get it. Okay. No problem. I'll send it to you today itself. Okay. Now when I teach you now on the basis of capital, you will argue with me, and if I get the argument na, I'm like, oh my god, so much of hard work I did. Okay, everything is fruitful now. But if you don't argue with me, then I'm like, are yaar, okay, all has gone in vain now. Okay, let's see. What is the argument? Open that notes. Tomorrow we'll finish this lesson and we'll start with another lesson, dividend lesson. Beautiful, chotu topic but very technical topic. See, based on capital. Okay, up till this we have done everything, JV and all, everything. Now, based on capital, listed companies and unlisted companies. Which companies beta? Listed and unlisted. Now, what do you mean by, first I'll do the tough part, okay, the tough one. What is unlisted company? Unlisted company means a company which is not listed company. The tough part we have done. Okay, unlisted company means a company which is not a listed company. Very good. Now sir, what is a listed company then? What is listed company? Now understand, guys, for you people, if I ask you what is listed company, you will be like, sir, any company listed on the stock exchange. Yes, no, any company whose shares are listed on the stock exchange, it is a listed company. Actually the answer is like that, but it is very technical. Now how technical it is given? See, generally a layman means a person who is not a professional. A listed company means any company which is listed on stock exchange. It's not wrong, but is not exactly absolutely correct also. We are professionals, we'll tell what is a listed company. So see, what is written? Listed company as per section 2 clause 52. It is a company which has any of its securities listed on any recognized stock exchange. If there is a company which has any of its securities listed on any stock exchange, recognized stock, there are only two stock, BSE and NSE. Okay, if there is a company which has any of its securities listed on any stock exchange, recognized stock exchange, that is a listed company. However, there are some companies whose securities are listed on stock exchange, but they will not be called as listed companies, guys. Now, which companies are these? However, following classes of companies shall not be considered as listed. First, which company? Public companies which have not listed their equity shares on a recognized stock exchange, which have not listed their equity shares. They have not listed their equity shares, but have listed their, what beta? Non-convertible debt securities, like non-convertible debentures. What do you mean by non-convertible debentures? Debentures which will not be converted into equity shares. They will be redeemed. Simple. Or which have listed their non-convertible preferences. Non-convertible preferences will not be converted into equity. So one thing I understood, sir, in case my company is a public company which has listed non-convertible debentures or non-convertible preference share, will it be a listed company? No. So in order to call my company as a listed company, which securities have to be listed? I have to list my equity shares, or I list my convertible debentures or preference shares, that is convertible securities. Then only my company will be called as a listed company. Understood? Here. Understood? Yes. Then we'll see the C point. Public companies which have not listed their equity shares on a recognized stock exchange, but whose equity shares are listed on a stock exchange in a jurisdiction as specified in section 23 subsection 3 of the Act. Sir, what is this beta? This is foreign stock exchange. Which stock exchange beta? Foreign stock exchange. Example, American stock exchange, Nasdaq. Yes. So basically, in case my company is a public company, but it has not listed its equity shares in Indian stock exchange or on an Indian stock exchange, but listed its equity share on a foreign stock exchange, will it be called as a listed company? That means one thing I understood from first and second point. If my company is a public company which has listed its equity shares or convertible securities on a recognized stock exchange in India, then only it will be called as a listed company. Am I clear with this? But if it has listed its equity share or convertible securities outside India, on American stock exchange, Luxembourg stock exchange, Will it be called as a listed company? But now, just for your information, guys, just for your information, it has not come in your RTP up till now. Central government recently has given, MCA, Ministry of Corporate Affairs, has given recently a list of stock exchange, foreign stock exchange. If your company's securities are equity shares or convertible securities are listed on those stock exchange, it will be considered as a listed company. Now, which are the stock exchanges is not in your syllabus up till now. Am I clear? Maybe in the RTP they will put it. Am I clear with this? Understood properly? Here everyone? Yes. Next, B point. If my company is a private company, this is also not a listed company, by the way. If my company is a private company which has listed its non-convertible debt securities, that means if my company is a private company which has listed what beta? Non-convertible debentures or non-convertible preference shares, will it be called as a listed company? But if it has listed, my company is a private company which has listed its equity shares or convertible debentures or convertible preference shares, will it be called as a listed company? Yes. Did you understand this? So if my company is a public company or a private company which has listed its equity shares or convertible securities on a recognized stock exchange in India, then only it will be called as a listed. Good. Online students, any doubt? Online students, any doubt? Online students, left or what? Online students, no doubt? No doubt? No. First point and second point, I'll tell you, don't worry. First is public company, second is private company. Understand beta, you should have a doubt. One doubt he asked, what's your name beta? Yash. Now what is the doubt? See, the doubt is, sir, you told if there is a private company which has listed its equity shares or convertible securities on a recognized stock exchange in India, then it will be a listed company, correct? But sir, yesterday we studied, can a public company be listed? Yes, obviously. But yesterday we studied beta definition of private company, that C point. Private company in its AOA prohibits invitation to public to subscribe securities. And yesterday I told you that's the reason only public companies can be listed, private companies cannot be listed. The reason is that private company cannot invite the public to subscribe securities. And if it is listed, though, it has already invited the public to subscribe securities. So now I am telling you that private company can be listed if it lists its equity shares or convertible securities. But yesterday I told you private companies cannot be listed. Do you remember? Only public companies can be listed. So now there is contradictory point. Either the definition section 2 clause 68 is correct or this point is correct. Answer is both are correct. I'll tell you how it happens. See, this happens because the second point, private companies point, will happen. Private companies securities will be listed on stock exchange. It will happen because of mergers and takeovers. Now see, I'll give you an example. This is actual example. There is a company JB Advani Private Limited. Okay. Delhi based company, private company, big company. This company, and there is one more company, Enercon Limited. It was a listed company. This is listed. Now JB Advani did a takeover of Enercon Limited. So Enercon Limited, a private company, took over a listed company. So this company got merged, Enercon Limited got merged with JB Advani. Now beta, there is a rule of merger. What is the rule of merger, you know? Okay, what is yours is mine. In Hindi we say, जो तेरा है वो मेरा है. What is yours is mine. Now Enercon Limited got merged. So Enercon Limited does not exist now. So all the assets of JB Advani will become assets of Enercon, sorry, will become assets of whom beta? JB Advani. All the properties of Enercon will become properties of whom beta? JB Advani. All the employees of Enercon will become employees of whom? JB Advani. Now what is your is mine? Same thing. Now Enercon, they took over by which, you know, purchase consideration. JB Advani purchased all the shares of Enercon Limited and diluted it. But Enercon Limited, they had issued debentures, and these debentures were listed. Now all the debenture holders of Enercon will become debenture holders of whom? Which company beta? JB Advani. Obviously that means beta, now JB Advani has to issue, okay, debentures to the debenture holders of whom beta? Enercon Limited. Okay, and they had issued also. Now tell me, if these debentures are convertible debentures. Okay, now before that, what is the rule beta? Beta, these debentures were listed of Enercon. So JB Advani will issue debentures. These debentures should also be listed. These debentures should also be listed. Did you understand? Now these debentures, if they are convertible debentures, what beta? Convertible debentures. So will JB Advani be called as a listed company or unlisted company? Listed company, because its convertible debentures are listed. Okay, so basically it will be, JB Advani will be a listed company. But if it is non-convertible debentures, then JB Advani will be listed or unlisted? Unlisted. Am I clear with this? Understood properly? So see here, did JB Advani Private Limited invite the public to subscribe securities? No. But are some securities of JB Advani, some debentures of JB Advani listed on the stock exchange? Answer is yes. So basically the company as a whole is not listed, but some securities are listed. Which securities? The debentures, okay, which are being held by whom beta? Debenture holders of Enercon Limited. Okay, only those debentures will be listed on the stock exchange. Am I clear with this? Understood? So the definition of private company is also correct, and this point is also correct. Okay, everyone understood? Anyone has doubt can just text me. If anyone has doubt, text me, I can explain it again, no problem. Anyone has doubt? No doubt? Sure? Clear? Okay, so what did we understand beta from this definition of listed companies? Sir, if my company is a public company or a private company which has listed what beta? Equity shares or convertible securities on a recognized stock exchange in India, then only that company will be called as a listed company. Okay, so can private company be listed company? Actually private company as a whole will not be listed, but only some securities of private company will be listed because of takeovers and mergers. Am I clear? Yes, that's it. So that is nothing but a listed company, and any company which is not listed is a unlisted company. Clear everyone? Perfect na? Great. So we have completed beta classification of company on the basis of what beta? On the basis of capital. Okay, so all the first 4 bases we have completed. Now we'll be doing beta other companies. Very simple. Now let's start with other companies, but as I told you, other companies are not miscellaneous. From here questions do come. So which all companies come in other companies? First we'll understand that. Okay, let's see. Other companies. Foundation people, do you remember? In other companies, which all companies come? First is government company. Which company beta? Government company. Second is foreign company. Which company? Foreign company. Third is a very important one for me, Section 8 company. Section 8 company. Fourth is a dormant company. Which company beta? Dormant company. Fifth is called as Nidhi company. Which company? Nidhi company. Sixth is public financial institution. And here classification of companies come to an end. Public financial institutions. Once you understand classification of company, boss, I'm saying now beta 20 to 25% of the battle is won. You now will understand all the provisions properly. Basically, you will not have confusions while reading. Public financial institution. Okay. Now, first let's start with government company. First one, government company. Sir, government company. Government company. Sir, what do you mean by government company? Understand. Section 2, clause 45 tells us what is a government company. Now see, government company means a company. It means a company. It should be formed under which act? Companies Act 2013 or any previous company law. Means a company in which 51%, how much beta? 50. Here it is not a majority, here it is 51%. 51% or more of the paid up share capital is held by. Who is holding beta? Is held by. Who's holding beta? Okay, I am writing here is held by either central government, okay, or state government, or central government plus state government, or central government plus state governments, like more than one state governments, or central government, no, not central government, okay, more than one state government, that is state governments. Am I clear with this? But how much beta? 51%. Now beta, when you quantify 51%, beta, very important here also, when you say paid up share capital, you have to consider what? Equity plus convertible preference share. Equity plus convertible preference shares beta. Am I clear? Sir, example of government company, understand. Example. Okay, in Bengaluru we have BHEL. What is BHEL? BHEL, not that BHEL. Bharat Heavy Electricals Limited. You have HAL also, Hindustan Aeronautics Limited. Then you have SAIL, Steel Authority of India Limited. Then you have GAIL, GAIL, Gas Authority of India Limited. All these are government companies. Am I clear? Guys, understand, very important. If I say Indian Railways, is it a government company? Is it a government company? No. It is a corporation formed under Indian Railways Act. So government company means a company formed under Companies Act. But 51% or more of the shares are held by government. Am I clear with this? Government company, Indian Railways, we say corporation, government department. Government company and government department are two different things. Tomorrow if you get job in BHEL, example, BHEL, HAL, SAIL, GAIL, will you be a government employee? Tell me, yes or no? Answer is no, Ray. You are not a government employee. You are employee of the company, not of the government. So in tax and all beta, okay, there is a provision for government employee, non-government employee. So you will fall where beta? Non-government employee. Government companies have to pay taxes. Government departments don't have to pay taxes. Government company prepares P&L account. Government department prepares income and expenditure account. Am I clear? Understood? Clear? Everyone. So boys especially, If you get job in bail, you are a CA. At the time of marriage, just for dowry, don't say you have a government job. You don't have. You are an employee of company, not of government. Just one important thing, that as it is a government related entity, because 51% or more is held by government, then the audit of this company is not done by normal auditors. The audit of this company is done by auditors appointed by C and AG. What do you mean by C and AG? Comptroller and Auditor General of India. C and AG. Now, how many of you don't know what do you mean by C and AG? Just raise your hand. You people know? Hey, no. Just raise your hand if you don't know what is C and AG or who is C and AG. How many of you do? 1, 2, 3. Okay. Okay. Hands down. I'll tell you. Beta CNAG, like India has one prime minister, one president, one defense minister, one home minister. CNAG, India has only one CNAG. Currently, who's the CNAG? You know, Sanjeev Murthy. Before this was Girish Chandra Murmu. Before that was Rajiv Mehrishi. Before that was Shashikant Sharma. He is like how you remember na prime minister, president names. You should remember CNAG's name. He has the power to make and break governments, guys. If tomorrow you become CNAG, beta, you give the report of how state governments are performing, and boss, that's a public document. You can destroy state governments like this. In fact, central government also. Unless and until you come, beta, budget meeting will not start. Until you sign, RBI's balance sheet will not be finalized. Finance Minister Devi ji, okay, will call you 5 times a day and take appointment from you. Okay, you will be that big person. Becoming CNAG is an achievement, boss. Every third guy will be a chartered accountant in some years. But out of crores of person, only one is a CNAG. Am I clear? So how many of you will work hard to become CNAG if you get an opportunity? Anyone? Online people? Huh? Yes, Noor Mohammed, very good. Very good. Okay, I'll tell you beta. Now after that, again you can answer a Noor whether you want to become CNAG. Like for becoming CNAG, yes, it will be an added advantage if you are a chartered accountant. But the official qualification is that you need to clear UPSC exam with IAS rank. You should be an IAS officer. You can get that, you can become CNAG. Now are you interested? Yes? If yes, raise your hand. No. Sir, let it be, sir. CA is better, sir. Oh. Yes, sir. Yes, sir. Very good, Noor. Yes, he wrote. Huh? I wanted to become. I didn't clear with IAS rank. Yes. Okay. Then, clear everyone? That is government company. I hope I'm clear with what is government company. Sure? Okay. Now, the next is foreign company. But guys, foreign company, I'll not take it here. There would be some points of lesson number 1 itself. I'll not take it here. Because if I teach you now, okay, maybe for exams also you'll write and clear, but you'll not get that good grip properly on that. And I always want my students to become professionals when they go in CA final. So that topic we'll do in a lesson. You have a separate lesson for foreign companies called as companies incorporated outside India. So there properly we'll study, not here. Now here it is not required. Now we'll start with section 8 company. Okay, an important part. Let's start. Now understand, guys. I'll write it in red only. Section 8 company. Actual, what is the name of this section 8 company? We call it as association not for profits or association formed for charitable objects. I clear? Yes. Now understand, this Section 8 company is divided into three parts. Like the content of Section 8 company is divided into three parts. First part is legal provisions. Second part is incorporation. How to incorporate a Section 8 company, form a Section 8 company. And third is conversion. How to convert a Section 8 company, non-profit company, into a profit-based company. Means how to convert a company not for profit into a company formed for profits. But now these 2 points. Now first in this lesson 1, I'll be doing with a legal provisions. Incorporation will be doing in lesson number 2 and conversion also after lesson number 2. As I told you now, there are certain things intentionally I will not do here because you will not get a good grip on that. Okay, because there are certain words in that part which you are not aware, and I don't just want you to just say okay, this is this, just remember it. No, every word which is legal word I'll write it down. I'll make sure that you are a pro in that, then only we'll study that topic. So incorporation and conversion, incorporation procedure is in lesson number 2. We will do that. Once we do incorporation procedure, we'll connect it with Section 8 company again, and conversion part again after lesson number 2. Okay. Now what is the legal provision? Let's start with the legal provisions. Guys, I'll tell you legal provisions everything. But I have one very simple question. If you can answer, online people and you people also can answer, just answer me. Section 8 company we call association form not for profits or association form for charitable object for social welfare. If I want to form I want to do social welfare or charity and all, why would I form a company? I'll form a trust, I'll form an NGO. No? Why the hell will I go for forming a company? Answer that. Foundation people have studied Section 8 company in their foundation. So tell me this answer. This is one of the interview questions which we generally ask. Why would I form a company? I would form a trust or an NGO, right? A trust also has separate legal identity. Why would I form? It's better and easy for me to form trust NGO. Why would I go for forming a anyone will go for forming a Section 8? Huh? Compliance burdens are less for trust for NGOs. NGOs to almost no compliance. Perfect. Better understand what people think now, how Section 8 company, because they hear the word NPO and all in YouTubes and all generally. So our 12th standard knowledge of accounts comes subscription, donations. Like they think, generally people think is Section 8 company runs on subscription, donations of others. Yes, you get donations. But if I had to resort only to subscriptions and donation and do charity, I will form a trust. I'll form an NGO. All these things come under the word NPO. Section 8 company also comes under the word NPO. So I'll form a trust or NGO. Why would I form a company? Answer beta, as I told you, I don't want to resort to donation, rely on donations and subscription of others from their money. I don't want to beg money from them and then do charity. No boss, I want to bloody earn money. And that money, whatever I earn, I want to give in charity. I want to do social welfare. Yes. And that's the reason what I'll do beta, I form a Section 8 company, because only companies will do business and can do business. Trust and NGOs cannot do business. I want to do business, earn money, and that money beta, I want to give in charity. That is what is a Section 8 company. That's the reason I want to form a Section 8 company. I'll give you an example of that. You'll be shocked to know this. Have you heard about one watch called as Rolex? So Rolex company is a Section 8 company. It's a company formed not for profits, which is earning huge surplus. 90% of the income goes into charity and 10% goes into research and development. I have one company, okay, Stainless Steel Association, not I was advisor of that company. Stainless Steel Association in Gujarat, Jain community people. Okay, whatever surplus they'll get in crores they were earning, steel business they were doing. 90% of the surplus goes into Jain community. Okay, funding Jain community, take a promotion of their religion, and 10% will go in research and development again. Am I clear with this thing? That is the reason I'll form a Section 8 company. If I don't want to do business, I just want to research and charity donation, I'll form a trust now. Why would I go for forming a company? Did you understand why people form Section 8 company? Am I clear? Okay. Like being human is an NGO. Is it a company? No. So whatever I'm telling, is it applicable to it? No. Am I clear? So see, first thing to sir, why do we call it as a Section 8 company? Why don't we call it as associate not for profits? Okay, the shortcut name is, or you can say nickname is Section 8 company. The reason is that if you want to function as a Section 8 company, you have to obtain a license, okay, from government, and that license is issued under Section 8 of Companies Act. Okay, so first is a license has to be obtained to function as a Section 8 company. Now who issues this license, beta? I told you government. Actually in government, na, understand, central government has the power to issue license and cancel the license also. But the power to issue license is given to ROC, delegated to ROC. So ROC, Registrar of Companies. What is ROC? Registrar of Companies issues the license under section U/S is under section 8 of Companies Act 2013. Am I clear? Now, so this ROC is not a normal, so this license is not a normal license like you go to DMart and tell give me 3 licenses. No, you have to give on a stamp paper, affidavit. Directors have to write. You know what is affidavit? Affidavit means in movies you might have seen this thing. Court scene is there, one witness comes and he'll put his hand on Bhagavad Gita and say whatever I'll tell will be true to the best of my knowledge. Yes or no? So that is called swearing. So orally if you give it is swearing. If you give it in writing, that is affidavit. Am I clear? Written swearing is affidavit. So on a stamp paper, directors have to give an affidavit, declaration. That was 3 declarations. These are the 3 pillars on the basis of which license will be issued to you. First, the main objects of the company. You have to write. Should it be profit based or non-profit? Non-profit. Should it be social welfare, charity, promotion of arts, commerce, science, religion, environment protection, sports development. Like BCCI, okay? BCCI, whatever IPL income it gets, there is no tax because they put it in charity. They show it is in sports development, not charity but sports development. Everything is exempted for them. Even though BCCI is not a company, okay, but then too it's a society. But that IPL income is exempt from tax. Am I clear? So see. So ROC issues a license. Okay, license is issued on fulfillment of the following 3 pillars I told. First, what is the first one? The main objects will be profit based or non-profit? Non-profit. A list is given that you have to do. Charity, promotion of arts, commerce, science, religion, sports development and all. Main objects are not for profits. Obviously, the second point tells the same thing. Can the company earn profits? No, company will never earn profits. Company shall not earn profits. Third is no member will be given dividend. Means company shall not declare dividend. What is dividend, beta? Distribution of profits. So obviously, beta, if there is no profit, can you give dividend? No. No dividend members. So these are the three pillars. On a stamp paper affidavit, you have to give it in writing. Directors have to give. Am I clear? Next. The next one, sir, when you get the license, now license has lot of benefits. Like first is tax exemptions you'll get. Okay, like every NPO gets, I told BCCI gets. Okay. Then beta, in a normal company, under Companies Act also you get exemptions. Normal company beta 4 board meetings. This company has to only hold 2 board meetings. Then I told you what is the maximum number of director in a company? 15. This 15 does not apply to Section 8 companies. Section 8 companies can have more than that. Then like whenever you conduct members meeting, normal companies, 21 days before the meeting you have to send notice to the members. This company has to give notice only 14 days before the meeting. So 21 days is not required to be complied. Then there are many committees to be formed in a company: audit committee, nomination remuneration committee, and all. For many companies, all the committees are mandatory. This company, many committees are exempted. If you don't form it, it's fine, no problem. So like this, many exemptions are given. Okay, so that is the benefit. One important benefit is that every company's name ends with the word private limited limited. This company is not required to end with the name with the word private limited limited. Okay, like I told you, what is my client's name? Beta Stainless Steel Association. Did I tell private limited limited? No, because the name is Stainless Steel Association. Association, confederation, council, this word trust. Trust nahi hai, trust will go under Trust Act. Okay. These words will come: association, council, confederation, federation. These words will come. Okay. So the name, the words private limited or limited is not required. Okay. The next one. Tell me, when you become CA, you'll get good salary, yes or no? But only good salary you'll get, or lot of work also you'll get? Work also, responsibility also. See how the company will run and why company exists. I'll tell you. The purpose of forming this company is not to earn profit. Example, I told you 100 rupees they earned. 100 rupees is the income. Out of that, they'll deduct their manufacturing expenses. Like my company is into steel business, manufacturing expenses, employee salary, director's expenses, everything, the cost of making the goods, take care, operational income, operational expenses, everything they'll deduct. After 100 rupees, if they get, example, 50 rupees left, that is their, what is there? That is their surplus. Out of that 50 rupees, take a 45 rupees they'll give in charity, 5 rupees they'll give into, they'll again put into research and development. Now you'll be like, sir, why will anyone form this company? Understand beta, the company, like this company, people who run this company, they don't have one company. There are many companies. Like my clients, Tata, Stainless Steel Association. They don't have one company, they have many companies, 5-6 companies they have. All the other companies are profit based. Only this company beta they have made non-profit. Am I clear with this? Understood, Akshata? Here. Okay, but as I told you, CA will get you good salary, but will get good work also, good amount of work. Yes, you'll be like, yeah, good. Why did I do CA? Sometimes it feels like that also. Okay, so yes, benefits will come with terms and conditions. Same here, license will come with benefits, but also with terms and conditions. The major terms and conditions is the 3 pillars which you have done. These 3 pillars. Can you do non-compliance of these 3 pillars? No. If you do non-compliance, beta, what will result? I'll tell you that. Am I clear with this thing? So license comes with terms and conditions also. Conditions as well. If you do not fulfill the terms and conditions, if there is a failure to fulfill the terms and conditions, so then beta, action will be taken against your company. Who will take the action? You know, who will take? No, there is one person called as regional director. Regional director. Now who's regional director? I'll tell you. See, at the state level under Companies Act, the biggest officer is ROC, Registrar of Companies. Every state has one ROC except two states which have two ROCs, Maharashtra and Tamil Nadu. Maharashtra has Mumbai ROC, Pune ROC. Tamil Nadu has Chennai ROC, Coimbatore ROC. But apart from these two states, all the states have only one ROC. Above ROC, at the state level, ROC is the head. Above ROC is regional director. He is the head of zone. India is divided into 5 zones: east, west, north, south, central. So basically, he is the head of zone. Above ROC, regional director. Above regional director is central government, head of whole India. So actually, I told you, power to issue license and cancel license is with central government, but power to issue license is given to whom, beta? ROC. Cancel the license is given to whom, beta? Regional director. Am I clear? So what regional director can do? Understand. He can do 3 things. First, he may cancel the license. Cancel the license and put penalty, okay, on the company as well as on the officers who are in default. Now what is the penalty and all? I'll write it later, don't worry. Punishment. So first is they can cancel the license. RD will cancel the license, declare you as a profit making company, and cancel all the exemptions given to you. Am I clear with this thing? Second, in case it is found that you form the company to do fraud. From one side you form the company and you took the benefits, exemptions, and you are also making profits. You are doing moe with the government. So at that time, regional director may order winding up. He may order winding up of the company, and after winding up, beta, all the assets are sold, debts are paid, anything surplus is remaining. Will it go to the members? No, then the members are in profit only. So basically, surplus will be transferred to a government fund known as insolvency and bankruptcy fund of India. Which fund, beta? Insolvency and bankruptcy fund of India. Here, beta, surplus will go. And third, beta, in case he thinks ki okay, you did not form the company for doing fraud, but only one director was doing fraud, and because of which non-compliance happened. So he may order merger of your company with another Section 8 company. Very important, beta. RD can order merger of one Section 8 company with another Section 8 company only. You cannot order merger of Section 8 company with a profit making company. That power RD doesn't have. In fact, nobody can do it. Am I clear? Central government in certain circumstances may do it. Am I clear with this thing? So basically, order merger with another Section 8 company carrying on similar activities. Similar activities mean charity, social welfare and all. Am I clear? Understood? Merger and amalgamation, I'll tell you officially or legally there is a difference. We say, I'll just tell you in small terms. Merger is fusion of control. One company wants control of another company. Okay, that's it. Amalgamation is of assets and liabilities. You want assets of another company. For that you do amalgamation. And that's the reason accounting standard also change. For amalgamation, there is accounting standard 14 applicable. Merger, it is not applicable. So there are differences in legal definition and there are differences in accounting treatment also. Okay, that you will understand properly when you will study mergers, amalgamation in final CA. Okay, now if I try to tell you, you will not understand because AS and all is still not done. That is the point. Okay, so but if legally if you say, it is for fusion of control, merger. Amalgamation is for assets. Am I clear with this? Now, okay, Now this three things he can do, plus he can put a punishment on you. Punishment. What is the punishment, beta? Understand, on company there is, he can put a fine. How much fine, beta? Fine is on company rupees 10 lakh to rupees 1 crore, and on officers in default who were involved in non-compliance, fine rupees 25,000 to rupees 25 lakh. Okay, plus he can award a punishment, okay, under section force punishment, under section 447. Now what is 447? In lesson number 3 we'll properly understand, but for the time being, jail up to 10 years if you intentionally did not follow the compliances, if you intentionally form the company to do fraud. Second method. Am I clear with this thing? Okay, did you understand? You are doing moe with the government will also do moe with you. Am I clear? Okay, now clear everyone? Okay, then two important points. Tell me, I told you there are two important documents, AOA and MOA, Articles of Association and Memorandum of Association. Can AOA and MOA be altered of any company? Can you change AOA and MOA of a company? Answer is yes, by members' approval. But this company's AOA and MOA you can change with members' approval, plus you have to take central government approval also. Sir, why, sir? The reason I'll tell you. Understand? In MOA, there are many clauses. In lesson number 2, you will properly understand. This also I was about to take in lesson number 2, but only small points I am taking it here. Name clause, situation, registered office clause, object clause, liability clause. Okay, like this. In that, object clause is there. Object clause, what the purpose of forming the company, main objects of the company is written. Now just imagine, beta, while forming the company, I wrote main object, beta, charity. Okay, then beta I got the license exemption, and then beta with members approval, what I did, beta, I changed the object clause from charity to profit making. Yes or no? So here I am taking exemption, and here I am doing what I am doing. I am earning profit also. Again moe I am doing. So that is the reason, beta, without central government approval you cannot change it. Am I clear with this? So AWA and MOA cannot be altered without CHIGI approval, beta. CHIGI means what, beta? Central government, not Chandigarh. You'll be like, sir, why Chandigarh is written here? And one point, sir, can you be a member in a company? Yes. Guys, can you be a member in a company? Yes. Can one company be a member in another company? But can a partnership firm be a member in a company? What do you think? Can one partnership firm? Answer, partnership firm cannot be a member in a company. No, you know why? Because partnership firm is not a person in the eyes of law. No, it doesn't have separate legal identity. And if it is not a person, can you make a non-person a member? No. Yes or no? Okay. So if the person doesn't exist in the eyes of law, can you make him a member? No. And that is the reason partnership firm cannot be a member in any company except in Section 8 company. Except in Section 8 company. Sir, why, sir? I'll tell you. See, logical reason if I give you, na, this company is formed for social welfare. So for social welfare, charity, money comes from anywhere, it's fine. But I'll tell you legal reason. You know the definition of partnership. Partnership is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. So partnership, can you form partnership for charity? Partnership should be profit based only. But if a partnership firm wants to do charity, it cannot do. So for that, better they have given an allowance. Partnership firm can form a company, be a member in that. Okay, and through that Section 8 company, they will do charity. Am I clear with this? So partnership firm can be a member Right. Am I clear, everyone? Okay, so we'll solve one question. Okay, this is exam question. Okay, we'll solve it here. The next one is exam question. I can directly show it from paper, but we have put in this notes only. See the question. Sai, along with his 6 friends, desire to incorporate a Section 8 company under Companies Act 2013. He is seeking your advice in the following matters. What is the minimum paid up capital requirement in case of Section 8 company? Did I talk about any minimum paid up capital? No. So there is no minimum paid up capital required. In fact, I'll tell you better, most of the Section 8 company will be company limited by guarantee not having share capital. I told you yesterday itself. Next, whether a firm can be a member in a Section 8 company? Partnership firm? Yes. Whether Section 8 company can pay dividend to its member? No, because that is the pillar on which you got the license. Very good. Are you online students left or what? You also have to answer. Next, P Cricket Club was formed as a limited liability company under Section 8 of Companies Act 2013 with the object of promoting cricket by arranging introductory cricket courses at district level and friendly matches. The club has been earning surplus. Of late, affairs of company are conducted fraudulently and dividend was paid to members. Wow. Mr. Y member decided to make a complaint with regulatory authority to curb the fraudulent activities by cancelling the license given to the company. First, is there any provision under Companies Act to revoke the license? Who can revoke, beta? Regional director. Whatever we wrote, you have to write everything and then answer to this. Whether the company may be wound up, yes or no? If it is found that the company is found for doing fraud, okay, then beta, after winding up, the whole money will be transferred where? Insolvency and Bankruptcy Fund of India. Whether P Cricket Club can be merged with Z Net Private Limited, a company engaged in the business of networking? No, why? Section 8 company can be merged only with a Section 8 company. Am I clear with this thing? Not with this is a profit making company. Am I clear with this thing? Understood? So this came for 5 marks in your examination. I'll show you that question, exact questions. हाँ, मैं तुमको एग्जाम में दिखा दूँ ना, देखो तुमको एग्जाम पेपर ही बता देता. अरे paper is very easy. We make it tough. I laugh on people who say na inters are very tough. See, State Cricket Club. Same question. Is there any provision under to revoke the license? Can the company be wound up? Can this company be merged with Net Private Limited networking? How many marks clear? Law paper is very easy. Provided, I always say this, you attend every lecture of mine properly, religiously, understand everything, there itself, but if you remember that much, you will clear. If you practice properly, 70 marks to easily you will get. MCQs, everything what we have done in the class. That's the reason I am taking example, this company, that company and all. More examples I'll take now, so that you will get a coverage of everything. Just by looking the question, you don't have to think also. Directly, this is what sir told. Am I clear? Okay. So online students, I hope you understood everything. Yes? Just a second, na beta, 1 second. Yeah, tell. They have to form a company. Partnership firm will form a company and become a member, or else if there is an existing Section 8 company, they can become member there also. But practically, they themselves form a company. Am I clear? They can. Yes. Okay. Once again, can you explain regarding merger and acquisition? Merger and acquisition, difference you want or what? Noor. Non-profit, simple. See, in mergers and acquisitions, that part, understand. In case it is found that the whole company was not formed with the intention of doing fraud. Company was formed for the purpose of doing charity, social welfare, okay, whatever is written in the affidavit only. But one director was involved in doing fraud. He was taking the profit illegally, and they were not following, and because of that it is told that company is not following the license. At that time they will remove that, RD will remove that person, the director, but without that director, the company cannot run also. In that situation, if the company can run without that director, they will directly cancel the license, they can make it a profit making company. But obviously that company was found for not for profit, but without that person the company cannot run. So they will, the RD may order merger of this company with another section 8, okay, and then do the charitable objects. Clear? Okay. Any other section 8 company, it can be private section 8 company or public section 8 company. Am I clear? If the regional director has a section 8 company which can be merged into, am I clear? Or else directly cancel the license and declare it as a profit making company. Clear? Any of the three options are there with the RD. Okay, it depends upon circumstances. Clear, Noor? Great. Okay, so here we rest our lecture. Okay, so I hope you understood everything. Tomorrow we'll finish this lesson and we'll start with dividend topic, a beautiful topic but a very technical topic. Okay, so that's it for the day. Bye bye, take care, bye bye.